your host, Gary Austin.
Hi, this is attorney Gary Austin back answering your questions about matters that relate to family law and divorce issues. So the question I've been given today is, how do we deal with debts that I don't think I'm responsible for? As you can imagine, when a divorce takes place, debts become a major issue because in California, a marital community, a husband and a spouse, are generally going to be responsible for the debts that come out of the marriage. So if you have a spouse who goes out and runs up a large amount of debt, the creditor or third party who is going to be seeking to be paid can go after you just like they could your spouse. Now, there are some exceptions, and judges, if they're looking or doing a trial and looking at these issues, there are some exceptions. One of those exceptions may be gambling debt. The real criteria that a court is going to look at is, was the debt incurred for the benefit of the community? And that's a very general way of saying, is this something that normally would come in the course of a marriage? A gambling debt may not be considered for the benefit of the community because it could be as a result of someone who has a possibly bad habit, who is taking money out of the community and squandering it for their own purposes. This is a very gray area of law, but a court can look at that and say there is no real benefit for someone going out gambling, unless, for example, we have a situation where maybe one of the spouses gambles for a living. So going and gambling would be to actually bring in income. One of the more classic examples that comes up in divorce often is, for example, someone is engaged in a relationship outside of the marriage and spends money on a third party. That cannot be considered for the benefit of the community because it's third party. It may be an extramarital affair or something along those lines. No court is going to consider that to be for the benefit of the community. And if that debt is located, determined, and traced back to that particular partner, that person will be fully responsible for it when it comes to divvying up or dividing up the assets and debts of the marriage. So if you have a situation where there is a big debt issue and you're trying to determine whether or not it is something that you would be responsible to as a part of a marital community, please feel free to reach out to us and let's talk and see if we can help you with that issue. Today's question is somewhat makes me chuckle because it happens day in and day out. And the question is, what if my ex-partner is making false allegations against me? Every day in family law courts throughout the state of California, allegations are being made that are hyperbole, exaggerations, or outright lies. What I tell clients is, you can't stop the other party from speaking. You can't stop them from lying. What you can do is position yourself to combat the lies as much as possible. When it comes to testifying in court, testimony is evidence. What I tend to tell people is spend your time finding as much information that you can that is clear, that is credible, and it creates confidence in the court that you are the more trustworthy, the more credible, the more honest person as between the two of you. Words will move judges only so far. So typically the best way to deal with false allegations is to have proof. I have a case currently where there's an issue related directly to spousal support, and one side is claiming they don't make money. Well, there are various ways in the law that you can prove that, in fact, either they are making money. One is discovery. Another one is, do they have certain educational credentials? What have they been doing in the past in terms of work? Because courts, under certain circumstances, can in fact impute wages, which means attribute a certain dollar figure to what a person can be earning. And in this case, we started with an individual who had not been working for years. They got a license to practice as a pharmacist. The court starts out by imputing them minimum wage, full-time minimum wage. It went from there to the next time we were in court, they indicated, oh, I'm making $50 an hour. And we believe they can make even more than that. But the allegation that they started off with, which we always thought was not the case, was false, is I'm really not making any money. The law does provide, again, ways to combat false allegations, but it usually is best to be done either with other documents or with experts or other people who can show clearly what this person is saying is not true, because you can't stop them, but you can convince a court, give that court confidence. And when it comes time to making a ruling, the judge is likely going to side with the party who is best able to support their allegations. Support is what shows that they're not false. And that oftentimes will come from something or someone outside of the parties. I know that's been a little bit of a lengthy explanation, but if you have a situation where you're in court, you're looking for some help ferreting through or looking through false allegations and trying to prove your point to a judge on an issue of divorce, child custody, child support, division of property, please feel free to reach out to us and let's see if we can work together to help you on that family law issue. Today, I'm going to touch on a story in a restraining order hearing that I once had. A restraining order in a family law case is probably one of the few what most practitioners, family law attorneys would say is a game changer. It's a game changer in the sense of that if one is granted against you, you may not be able to collect spousal support, which is oftentimes a very big issue in divorces. In addition, probably where it affects you the most and immediately is if it is granted, there is an immediate impact on child custody, where you cannot be granted sole custody if you are the restrained person or the abuser, as some people term it. You may have to have supervised visits, and you more than likely won't have joint custody, except in a very small percentage of cases will even joint custody be granted. Now, oftentimes I talk about issues that are related to evidence and procedure in trial, but what I tend to think is the biggest issue for a client is credibility. So I had a restraining order a couple of years ago, and there were several allegations against my client for domestic violence. The end or conclusion for you who are watching this is, it is very important to have credibility to maintain a sense of calm as you sit there and weather the storm in court. One of the other videos we've done, and it's in this series, is what happens when false allegations are being made against you. When a restraining order hearing, there are going to be false allegations made. And in this specific case, the client could not contain himself at counsel table. He would, and grunt and grimace and turn. And the hearing went on for about 3 days, 3 afternoons, so I'd say a day and a half. And for the first 2 days of the hearing, he could not control himself as we sat at counsel table. So much so that during breaks and at the end of the hearing, he would address the judge or the court directly. One of his statements that he said is, "Can't we stop this? We're wasting our children's college fund here." Now, what that did in terms of credibility, the statements, the gestures while he sat at counsel table, the size, it destroyed his credibility. Because when we reached the end of the case and we had evidence, clear, direct proof that the other side was being dishonest, was exaggerating things. The judge said so. It says, I'm not going to believe that. But that crucial which way do you lean came in. And on all the other counts where there wasn't direct evidence and it was his word versus hers, the judge went their way. I believe at the bottom of my heart, had there been more acceptance that the other party was going to lie and the ability to contain or control himself simply to get out of the courtroom and express it to me instead of the court, we would have won that case. Because the first allegation that was put forward, the most recent, was discredited. It was undermined and the judge didn't believe them. But judges are people too. I tell people that all the time. And because judges are people too, they pay attention to what you say, your body language, how you react to certain things. And your reactions, if they go on repeatedly or continually, or they're ongoing, they will give a judge the impression that you are being dishonest. So in a restraining order hearing, when all those consequences are before you, if you lose, and there are going to be some lies, the ability to be credible, the ability to be calm as you possibly can, and follow as best you can your lawyer's lead, may be the difference between those consequences and you walking out there being able to collect spousal support if that's an issue, and certainly being able to stay in your children's lives without all the consequences that come with a domestic violence restraining order. So if you are facing false allegations in a domestic violence situation and you're looking to work with someone to help you move through it, be successful, and get back into your children's lives or back on path with a divorce, please reach out to us and let's talk about working together.